Law Collaborative presents Ron and Robert on Divorce. Here are attorneys Ronald Supanchik and Robert Borski with California Family Law. And welcome, Robert Borski here with my partner,
Ron Supanchik.
And we've got a great show for you today from the Honorable Thomas Trent Lewis.
We're very pleased to be in the position of being able to talk to one of the most respected and admired judges in the Los Angeles County Superior Court system, a family law judge who's a certified family law specialist. He practiced family law for 28 years and about 4.5 years ago was elevated to the Superior Court, where he has sat in family law. Judge Lewis, I happen to know that when you were an active member of the local bar association, you chaired the legislative committee and took legislation forward that gave the courts the power to order counseling for families. And I'm very curious, as a practicing or as a judge now, serving in the capacity of making decisions for families, have you found that to be a useful tool?
I think it's a very useful tool to be able to order counseling. Of course, the statute had its beginnings because of a case that you were involved in, Ron, where the trial court made an order that allowed counseling and actually mandated individual therapy for one of the parents.
Marriage of Camacho.
Marriage of Camacho, and that was, I want to say, an 88 case or thereabouts.
Sounds right.
Subsequently, the District Court of Appeals said that the Family Law Act did not provide authority for the court to order counseling. Just by way of some background, in other venues besides a straight family law case, particularly in dependency proceedings where children are declared dependents of the court, parents can be ordered into counseling, and the Supreme Court later said that we can implement those orders, but there was a gap, and the gap was in the typical family law case. What kind of authority did the court have to order parents to be involved in some kind of counseling? A countervailing consideration, of course, was counseling can be used as a weapon in the hands of a perpetrator of domestic violence, so the court has to be mindful of that. The legislature decided to fill that gap with what is now Family Code Section 3190, and I have ordered counseling on many occasions, as have several of my colleagues. There's some debate amongst judges about whether or not the enabling statute permits a court to order individual therapy for a parent. I think Camacho is still the law, and that there's only a limited setting in which the court could order a parent into individualized therapy. But there is broad discretion to order parents into some kind of one-year counseling on terms that the court has to define clearly, and I think that that's a very useful tool. For many parents, it's about education, it's about getting some distance from the pain and the anger, the denial and the wounds of a broken relationship, and so sometimes through counseling that can be minimized. For some families, the counseling venue creates an alternative for high-conflict families to sort of sort it out with a counselor, as opposed to running back and forth into the court system, which is, of course, slow because of the delays that it takes in terms of getting a court date. So it can frequently be a good tool. Now, it can be a tool that can be misused, like any tool, and there are settings in which counseling is simply used by one parent or the other to punish or replay old scripts about past wrongs and pain. I don't think that's what the legislature had in mind. I think it is a good tool. Sometimes cost is a factor, but it's certainly, I think, a good tool, and I think getting more and more use. Partly because I've been advocating more and more use of it, but I think it's been getting a lot of use, and I think it's a great tool.
You did something else that I think is very important and worthy of discussion. You convened and served on a committee as a bench officer. I guess the committee was convened by the supervising judge. I'm speculating, but you actually put together a program to offer families a plan for parental coordination, a Planned Parent Coordinator, a new option to allow families to find alternative ways of resolving family conflict short of outright warfare. Talk a little bit about that committee, the work of the committee, and the result.
Sure. The committee was put together by our supervising judge about, I want to say, 3 years ago, and the people that served on the committee consisted of a couple of mental health professionals, a couple of judges, and a couple of lawyers. I think altogether there were about 10 of us. Just by way of some background about what a Parent Plan Coordinator is, a Parent Plan Coordinator typically is it can be a judge, it can be a retired judge, it can be a lawyer, it can be a mental health professional. Our law does not permit the court to order parents into this kind of setting. It takes an opt-in by the parents where they agree, with sometimes the benefit of their lawyers, that they're going to have somebody outside of the judicial system as a neutral to try to make decisions for them in various areas and opt out of the court system. For high conflict families, it's a great tool. What the panel did was to develop a very comprehensive Parent Plan Coordinator Stipulation, which has become a model throughout the nation, in fact, indeed, internationally as well. And it's available on the LA Superior Court website. It's designed to implement a method for the parties to opt out of the court's normal method for deciding custody cases and create a forum for parents, sometimes with lawyers, frequently not with lawyers, but just the parents and the coordinator trying to work through that process. This is an area that is still evolving, and there are some wonderful tools that are available through, if I can just pitch, the Association of Family and Conciliation Court California chapter, and the international organization has lots of training in this area, and it's a very evolving area. The whole idea is to exit the court system and see if the parents can, when they have access to somebody neutral, both develop better skills at resolving conflict themselves, and when somebody has to make a decision, then the Parent Plan Coordinator, if by stipulation, can act in that role.
This is an amazing new development where it appears that the courts are taking advantage of technology to make tools available to the public and to their counsel. What are some of the resources now that are available to the public that they may not even know about?
I think one of the best tools out there right now is the Our Family Wizard program, and there are some others that are available. They are internet-based. They're designed to have the parents communicate using the internet. There are very few folks that don't have access to the internet, and even if they have limited access, they can always go to a public library and gain access. The Family Wizard is a tool for posting information, schedules, and verifiable communication that can be looked at by the lawyers. It can be looked at by the evaluators. Judges could have access to it. I don't think it's appropriate for a judge to be surfing the internet and looking at the parties' communications. That's an ex-party communication, I think, inappropriate. But certainly a parenting plan coordinator could be provided access to that information. And the purpose of it is to create a verifiable way where the parents can communicate with each other, and that information can then be provided to the court. A common order that I'll make is that enrollment is to occur by a particular day. The parents are to enable the text feature so that they can get an internet email that tells them that there's a message or information waiting for them. To really get granular and drill down to things like saying the day that the postings are to take place. I will typically order postings at 6:45 p.m. on Monday, Wednesday, and Friday, and order the parents to check it the sooner of 7 p.m. on Monday, Wednesday, and Friday, and or if they get a text alert. And the nice thing about those programs is that it is verifiable, it is comprehensive, and if the parents communicate in a business-like way, then they can be about the business of parenting, which is what their responsibility is once the relationship is over. They still have a business relationship, if you will, as parents. And I think it's a good tool to make sure that that happens in a way that's effective and promotes the best interest of the kids.
And we'll be right back with more with the Honorable Thomas Trent Lewis in just a second.